Hello and welcome to Fair Housing Protections for People with Disabilities. My name is Kara Birdfear, and I'm a senior attorney here at the California Civil Rights Department. Before we get started, I'm going to give you my boring lawyerly disclaimer that this information is for informational purposes only. We're not giving you legal advice. We're not establishing policy. And this information is current as of today, but the law is always changing, so this information could change in the future. Here's our agenda for today's training. First, we're going to start with just a brief amount of background on what we do at the Civil Rights Department. Then we're going to talk about reasonable accommodations, and we're going to end with reasonable modification. Here's a bit about what we do at the Civil Rights Department. We have a large job in that we're charged with enforcing civil rights laws that protect the people of California from discrimination in housing, employment, and public accommodations. We also enforce laws that prohibit hate violence and human trafficking. And here's a quick list of a lot of the things that we do. We are many times known still as the Department of Fair Employment and Housing. We actually changed our name a few years ago to the Civil Rights Department, and we are known for investigating and taking complaints of discrimination and other civil rights violations. When we get these complaints, we often will facilitate dispute resolution or mediate these cases to try and resolve them. We sometimes go to court and we prosecute the laws that we enforce, like the laws that prohibit housing discrimination. We have a civil rights council appointed by the governor that takes the laws that we enforce and they write regulations to give more clarity and information to the public about how those laws should be enforced. We do outreach and education, like what I'm doing right now. And we also do community-based dispute resolution to resolve discrimination-based conflict. And this is a little information for people with disabilities who'd like to access our services. If you or someone you know requires an accommodation to access our services, this is what they can do to make that request. And here's some similar information for people who require CRD services in another language. This is how you can make that request. And here are the housing related laws that we enforce at CRD, and these are going to kind of form the basis of the protections that I'm going to talk about today. First, we have the Fair Employment and Housing Act. The Fair Employment and Housing Act prohibits discrimination in housing and employment. It also prohibits harassment in both housing and employment if that discrimination or harassment is based on a protected characteristic. We also enforce the Disabled Persons Act, and this gives people with disabilities the same right to the general public and the full use of public places that everyone else has. We also enforce the UNRRA Civil Rights Act, which prohibits discrimination and harassment in businesses in California, and this includes housing accommodations. Also, we enforce laws that prohibit recipients of people who take money from the state from engaging in discrimination. So let's talk about what a protected characteristic is. This can be a somewhat difficult thing to describe, but I think when you get some examples, it makes it a little more clear. But basically, a protected characteristic are things about a person or a group of people that are protected by the law from discrimination. For example, the law protects people from discrimination based on race, so race is a protected characteristic. So here's a list of the housing protected characteristics in California. These are the characteristics that are protected from housing discrimination. You should know that there is a federal law called the Fair Housing Act, and it's a law that applies to the entire United States. And there are protected characteristics that are protected from discrimination across the country, and those are included in the California law, but California also has many other protected characteristics as well. And I'm just going to highlight a few of those. We have sexual orientation, gender identity, gender expression, source of income. So if you use a Section 8 voucher, for example, you can't be discriminated against for that. Your primary language, your immigration status, and citizenship. And you should also note that if you have these actual protected characteristics, maybe you're a person who is transgender, you would be protected. So if you have the protected characteristics, if you're perceived as somebody who has these protected characteristics, maybe someone thinks that you're transgender and you're not, you would still be covered by these protections. Or even if you're associated with a person with a protected characteristic, maybe you're a parent of a child with a disability, you would still be protected by these laws. There's also what we call rights that flow from protected characteristics. These are also housing discrimination related protections that are not protected characteristics in and of themselves. One of those is the right to be free from housing harassment based on protected characteristics, the right to operate a licensed childcare in your home, and we also have specific protections for people with criminal histories who are looking for housing. And now we're going to talk about reasonable accommodation. This is the main basis of the disability-related protections that come from FEHA and the other laws that I talked about. And let's talk about the definition of an accommodation or a reasonable accommodation. A reasonable accommodation is basically just a change in rules or policies to allow someone with a disability equal use of housing. And I like to tell people that reasonable accommodations can be really powerful tools to help people with disabilities to get into housing and to maintain housing that works for them. Some examples of reasonable accommodations, just so you know, this is not a full list. Accommodations can really be anything that if the person who's requesting it can show that it's necessary because of their disability, and you can really be creative with these. But here's some examples. Changing a no pets policy to allow an emotional support animal, giving someone more time to meet deadlines or comply with notices. For example, say your landlord asks you to remove something you have on your lawn and you have a physical disability that would make that difficult, you can ask for more time to move out. Say you have a disability related reason why moving out might take a little longer than usual, you could ask for an accommodation for that. Allowing somebody to have a live-in aid, giving somebody an assigned or a closer parking space. Economic accommodations are also examples of reasonable accommodations, like allowing a co-signer if a landlord normally doesn't. Also, waiving a fee if someone with a disability has to break a lease, maybe they have to leave because there's a disability related reason. You could ask for an accommodation to waive the fee for breaking a lease. But again, any accommodation, anything could be an accommodation as long as there's a disability related reason why it's necessary. So here's my super nerdy acronym for the steps of the reasonable accommodations process. It corresponds to the letters in DANCE. So we have D, disability, A, accommodation, N, necessary, C, cost, and E, effect. Step 1 is disability. So in California, the definition of disability is a pretty broad definition. It's more broad than the definition of disability in the federal laws that cover the entire country. But basically, in California, you're a person with a disability if you have a physical or mental impairment that limits one or more of your major life activities. And I'm going to talk about what those are. It can also be a record of having an impairment, or even, as I talked about before, if someone thinks that you have a disability and maybe you don't, you would still be covered. And major life activities are basically the things that you need to do day to day to care for yourself, to go about your day. Things like, physical activities like walking or eating or hearing or working. Psychological or cognitive activities like learning or reading, working, interacting with other people, and even, how your body functions, things like your respiratory, digestive, or immune system. These are all major life activities. And so if you have a condition that limits one or more major life activities, you are considered to be disabled in California. All right, step 2 in the reasonable accommodations process is requesting an accommodation. Obviously, you need to ask the housing provider for a change to a rule or policy. For example, I need a closer parking space. You don't actually have to use any type of magic words. You don't have to say reasonable accommodation. You don't have to say, I'm exercising my rights under the Fair Employment and Housing Act. You just need to make the request. And housing providers often ask you to fill out forms for accommodations. This isn't legally required, although I do tell people that having a paper trail or having something in writing can be helpful just to document and keep track of this process as it goes forward. You could also send an email or a text or a letter. This should all be accepted and equally considered. Our first question, we're obviously not doing this live, but play along at home. True or false, a reasonable accommodation can be requested after a court has ordered an eviction? And the answer is true. So let's talk about it. So let's talk about timing of reasonable accommodations. So an accommodation can be requested at any time from before someone moves in to when the tenant is physically out of the unit, and even after they're physically out of the unit. So say you're a person with a physical disability, and because of your disability, you had to leave some of your belongings behind. You could ask for an accommodation to have the housing provider store those for maybe a reasonable amount of time, and maybe you would pay for some of that time of the storage. But the idea and the reason I'm bringing this up is because I want to hammer home that an accommodation can really be requested at any time. You can request it when you're at a trial for an eviction. You can request it after the court has said, hey, you need to be out. You can ask for more time to move. So an accommodation can be requested at any time. All right, step 3, necessary. So an accommodation has to have a disability-related reason why it is necessary. And the requester, if asked for proof, only has to give as much information that's needed to demonstrate why the accommodation is needed. The requester doesn't have to disclose a disability. They just have to give enough information, things like specific symptoms, just to show why the accommodation is necessary. All right, and poll. Who can provide documentation of a person's need for a reasonable accommodation? So if a housing provider requests proof, who can provide this documentation? So we have A, a licensed medical professional, B, a therapist or social worker, C, the requester themselves, D, the requester's parent, child, or relative, E, all of the above, or F, both a licensed medical professional, a therapist, or a social worker. And the answer is E, all of the above. So let's talk about it. So documentation of need, it's not necessary. The housing provider doesn't have to ask for it. And they can ask for it unless the need is readily apparent. And what we mean is if the need is obvious. So for example, if somebody who uses a wheelchair wheels himself into the property management office and says, hey, I need a closer parking space, it's going to be very clear that the person has a disability related need to have the parking space closer. And it's going to be clear that this person has a disability, so the housing provider should not ask for more proof. And also, documentation of need does not have to be from a licensed medical professional or somebody in healthcare. And honestly, in my practice and what I've heard in the community is oftentimes doctors are not great people for giving this type of documentation because they don't really know the day-to-day activities of a person with a disability that they're maybe treating for a medical condition. It's oftentimes people like a social worker or a caregiver or somebody else that might have that relationship with that person with a disability that can document that need. And for this reason, this documentation can come from any reliable third party in a position to know about someone's need for an accommodation. This is not an exhaustive list or a complete list. People like social workers or therapists, peer support groups, non-medical service agencies. Maybe you got help and you're a person with a disability that got help from a service agency that provides services to people with disabilities. Someone who caretakes for the person or as a caregiver for a person with a disability. For example, a live-in aide or a parent of a child with a disability. So it can be any third party. And it can also be the person requesting the accommodation themselves. Oftentimes, people with disabilities are the best person to document and discuss why an accommodation is necessary, and they could provide proof of the disability maybe by showing public benefit statements that they're receiving SSI, for example. So all of those areas and people can provide documentation of the need for an accommodation. All right, here's another hypo. This is Hannah. Hannah is applying for a vacancy with Carol, and she notifies Carol that she's going to be bringing an emotional support animal. Carol wants proof that Hannah's dog is a real emotional support animal. And Carol tells tenant Hannah that she needs like a certificate or registration for Hannah's emotional support animal before she can have it in the apartment. Can landlord Carol do this? What do you think? And the answer is no. And so there's no legal requirement that an animal who's an emotional support animal should be registered or certified in order to serve as an emotional support animal. There's a lot of online businesses that say that they're going to register or certify your emotional support animal, give you a card, give you a vest. Most of these websites, when they're just doing registration and giving you a card, they're actually scams because there is no emotional support animal registry, and you don't need to have any type of registry or certification to be an emotional support animal. At the same time, there are service animals that are trained to do a specific task to assist someone with a disability. The animals like blind guide dogs for the blind or dogs that can tell when someone's having a seizure. These are service animals. It's different from emotional support animals. And service animals, a housing provider or other provider can only ask 2 questions to show the need for the animal to live in a unit. Are you a person with a disability? And what type of activity or task is this animal trained to do? So those are 2 different things. There's emotional support animals and then there's service animals. All right, step 4, cost. So housing providers, for the most part, must absorb the cost of granting an accommodation unless it's what's considered to be an undue financial burden. And what this means is it's just so expensive and it's going to be at such a great cost that it's just not going to be possible. And showing whether something's an undue financial burden is going to be different for every housing provider. It really is determined on a case-by-case basis. For example, if a housing provider just has 1 unit in their backyard, they're going to have way less resources than a housing provider that owns an entire apartment complex. So you're really looking at things on a case-by-case basis. But if a housing provider believes that accommodation is going to result in an undue financial burden, she has to engage in what is called the interactive process. They have to talk to the tenant or the person requesting to see if there's a less expensive option for meeting the needs of the person with a disability. Housing providers should not just automatically deny an accommodation request. They should engage in this discussion. And interactive process, it's really meant to be a discussion. Both parties get together, they talk about what the need is and try and come up with a solution. And step 5, effect. So An undue financial burden can allow a housing provider to deny an accommodation. Also, if the effect of the requested accommodation is what's called a fundamental alteration to what the housing provider does, and I'm going to talk about what that means, they could also deny the accommodation. So what this means is what's being requested by the person with a disability not related to the services that a housing provider would normally provide? Is it just really outside of that? For example, I had a client who requested that her landlord do her grocery shopping as a reasonable accommodation. And her landlord said, no, because I am a landlord. I don't normally shop for people, and it's really outside of what our landlord tenant relationship is. So that would be considered to be a fundamental alteration, and a housing provider could deny that request. All right, this is another hypothetical. This is Abigail. Abigail has a disability and she receives SSI, or Supplemental Security Income. It's a government benefit based on her inability to work because of her disability. She requests a reasonable accommodation that she be permitted to pay rent on the 4th of each month because her benefits are often not deposited until the 3rd of the month. So let's go through it and see how you would evaluate this request. So one, Abigail is disabled. She's a person with a disability. She gets SSI benefits due to her disability. So A, accommodation. She made a request for an accommodation to pay rent after her benefits come in. Necessary. There's a disability-related need why Abigail needs this accommodation. It's necessary for her to continue to live in her home, and it's related to her disability because she is receiving her benefits that she uses to pay for her housing later than when the rent is due. And cost. So is it going to be an undue financial burden for the housing provider? No. The cost of accepting and processing rent a few days late would be really minimal, and the need to Abigail is much higher. And the housing provider, if there is any cost or small amount of cost to accepting rent a few days late, would have to absorb that cost. And effect. Abigail is not asking the housing provider to do something really outside of what housing providers or landlords normally do. She's just asking for them to accept her rent late. So in this case, Abigail's landlord should approve this request for an accommodation. All right, let's do another hypothetical. This hypothetical is Rowan. Rowan is a veteran with a mental health disability that makes it difficult for him to get out of bed, leave the house, and do other tasks necessary to take care of himself. His therapist recommends that he get a dog to motivate him to get out of the house and to provide companionship. I will say I got a dog during the beginning of the pandemic, and it definitely got me out of the house. Despite his building's no pet policy, Rowan adopts a pit bull mix who he takes on walks twice a day. And his landlord sees the dog and serves him with a notice to get rid of the dog or he's going to be evicted. The notice also says that pit bulls are never allowed on the property because they are dangerous. Rowan is terrified of losing his housing, but is also very dependent on his dog, so he just ignores the notice. His landlord files an unlawful detainer, it's an eviction, in California to evict him. At the eviction trial, Rowan explains that he needs the dog to help him manage his disability. So let's go through. So timing, first, is it too late for Rowan to request an accommodation? And the answer is no. As we talked about earlier, accommodations can be requested at any time, including at an eviction trial. Disability, Rowan has a mental health disability. And accommodation, he did request to be able to keep the dog despite the no pets policy because it helps him manage the symptoms of his disability and necessary. Without the accommodation, Rowan will be evicted. So the accommodation is definitely necessary and is related to his disability. And cost. Changing the policy to allow the dog would probably be a very low cost to the landlord. So it would not constitute probably an undue financial burden and effect. This isn't a fundamental alteration or a really big change to what the housing provider is required to do in their relationship with the tenant. So that would not be a reason that they would deny the accommodation. So in this case, I would say that Rowan's landlord should approve this accommodation. One thing to note is that if this accommodation is approved, the landlord cannot require additional security deposit or additional rent because the emotional support animal is not considered to be a pet. It's considered to be related to his disability, kind of similar, although it sounds strange, to a medical device. But Rowan will still be responsible if, for example, the dog does damage in the unit that's above ordinary wear and tear. Rowan would still be required to pay for that damage. But what about the landlord's policy of not allowing pit bulls because he thinks they're dangerous? So a reasonable accommodation can also be denied if the effect of it would constitute a direct threat to the health or safety of others in the building, or would cause substantial physical damage to the property. And these risks can't be lessened if you provided another type of reasonable accommodation. So here, Rowan's landlord would have to show that the dog itself, Rowan's specific dog, risks significant direct threat to health or safety. So it's so dangerous it might hurt somebody or cause substantial property damage. And this direct threat can't be based on stereotypes, things like, certain breeds of dogs are more dangerous than others. It has to be based on the specific accommodation request, or in this case, the specific dog that Rowan wants to have as an emotional support animal. Not all pit bulls are dangerous. Many pit bulls are very good pets. The only dog that actually ever bit me was a Chihuahua, a teeny tiny dog. So, all dogs are different. And so requests for accommodations and whether they're a direct threat have to be analyzed on a case by case basis. And this means that having a breed restriction, like saying no pit bulls, is not allowed. Okay, let's do another hypo. This is Joe. Joe has been living in the same one-bedroom apartment for 10 years. His landlord has given him several violation notices due to excessive items in his unit. He has so much stuff that it's impossible to walk around the unit, and Joe can open the door just wide enough so he can slide in and out. The landlord says this is a fire hazard. She also suspects that Joe may have infested his unit with bedbugs due to bringing some items in off the street. The landlord is willing to treat the unit for bedbugs, but the exterminator can't even get inside to spray due to all of Joe's possessions. Fed up with giving Joe numerous chances to clean his unit, the landlord issues a 3-day notice to move out. Joe tells his landlord he started accumulating a lot of possessions as a way to deal with his depression, which started after the death of his partner, Stephen. Stephen's family didn't approve of the relationship and wouldn't let Joe keep any of Stephen's possessions. He says he wants to clean his place, but gets too overwhelmed every time he tries to throw anything away. Can a reasonable accommodation help Joe? So this is a much more complicated situation. I think some of you on this training or watching along may have met folks with similar situations, and let's talk about it. So let's talk about it. So here, disability. Joe has a disability. He has depression and likely also has a hoarding disorder, which is also considered to be a disability. And the accommodation. So some possible ideas for accommodations Joe could request are to give him more time to clean his unit. Maybe he can show that he's getting support from a mental health professional or another organization that's maybe providing services for people with hoarding disorders. He could ask that the 3-day notice to move out be withdrawn, and maybe he can stay in the unit, possibly on a probationary basis. So maybe the landlord could say, hey, I'm going to inspect your unit every month for 6 months to make sure that you're keeping it clean. And if you are, then, the eviction will go forward. It could really be anything. And I like this example because it shows that accommodations are dynamic based on the facts and, could really be anything. And it really is important for folks to get together and try and come up with a solution that works for everyone. Necessary. So this accommodation is related to Joe's disabilities and it's necessary because without it, Joe will have nowhere to live. The cost, Joe's landlord would really have to consider if it's going to be an undue financial burden. It's probably not. Housing providers are usually required to absorb costs, but sometimes in these situations, maybe the bed bugs and Joe's presence are impacting other tenants, and that could, allowing Joe to stay could constitute an undue financial burden. But for the most part, housing providers are required to absorb costs of accommodations and effect. So Joe would have to consider, whether letting Joe's landlord would have to consider whether letting him stay would be maybe a direct threat to health and safety. Maybe he is really concerned about the fire hazard. Maybe maybe the condition of Joe's unit is raising other concerns. So it would really depend on the facts and circumstances. But I think this is a great example just to show that, most situations an accommodation might be necessary and possible to keep someone in their home. Okay, now we're going to shift gears a little bit and move on to reasonable modifications. So accommodations, just as a recap, are changes to rules or policies, but reasonable modifications are different. They are actually physical changes to housing to allow a person with a disability an equal opportunity to use and enjoy housing. And like a reasonable accommodation, the failure to allow a modification is also considered to be housing discrimination. Some examples of reasonable modifications, installing grab bars in a bathroom, maybe in the shower or next to a toilet to allow someone with limited mobility to get up and down and to move about safely. Installing a wheelchair ramp over stairs. A doorbell that flashes for someone who's deaf so they know that someone's at the door. Widening a doorway for a wheelchair or lowering cabinets to allow someone with limited mobility or someone using a mobility device to access cupboards. All right, another question. Is it always the housing provider's responsibility to pay for reasonable modifications? And the answer is no. Let's talk about it. So, for the most part, housing providers are actually not required to pay for physical modifications. It's usually on the tenant to make payments and to pay for these changes. But under some circumstances, housing providers are required to pay for modifications. First, if the housing provider is providing housing that is government subsidized, maybe with the housing provider is a government entity or they receive federal or state funding for affordable housing, sometimes those housing providers are required to pay for modifications. I will note that this does not include if a tenant is using a Section 8 voucher. A Section 8 voucher is used to rent private housing, and that does not obligate the housing provider to then pay for physical changes to a unit. Also, modifications would need to be paid for by the housing provider if they're needed because the housing provider maybe didn't maintain housing, and especially if it's an accessible feature like an elevator. If someone with a physical disability, needs an elevator in order to access their unit on the third floor, the housing provider has to maintain that elevator in good working order. Another scenario where a housing provider would be required to pay for a modification if when the housing was built, there were laws in place that required certain types of features so they'd be accessible to people with disabilities. In California, there are certain requirements for new housing. If the housing provider didn't do that when it was built, and then someone subsequently says, hey, I need my doorway at a certain width, or I need this to happen, and they didn't do it when it was built, the housing provider would be required to pay for that change. Denial of a reasonable modification. So a housing provider can deny a tenant the right to make a reasonable modification. One, if the person requesting isn't disabled or can't demonstrate a necessity that's disability related. If the requester refuses to pay for the modification, unless the housing provider is required. So if the requester can't pay for the modification, then it can be denied because it's not the housing provider's responsibility to pay. Also, if the requester isn't giving the housing provider enough information so they can evaluate it, maybe plans or making sure that it's done, competently. It's not just done by some random person, but someone who knows what they're doing. And also, if the person requesting is has to agree to restore changes to the unit when they move out, and this is only a requirement for the interior of a tenant's actual unit. But if they do work on the common areas, then that can't be required. So if a housing provider is required to pay for a modification, for example, if they are a government entity, they can deny the request for the modification if it's going to be an undue financial burden. So, like reasonable accommodations, this needs to be analyzed on a case-by-case basis, really looking at the need and also the resources of the housing provider. For the most part, housing providers would be required to absorb these costs if they are required to do the modification, but sometimes the request is just too large. For example, if a tenant with a disability is asking for, an elevator to be installed, I think that would probably be very difficult and very cost prohibitive. But if a housing provider gets a request that would not work because it's an undue financial burden, they should still interact with the tenant in the interactive process and try and come up with a more viable solution. All right, this is Miko. Miko has physical disabilities that make it difficult and painful for her to navigate stairs, and the pool at her apartment complex has a pool lift that Miko has used consistently over the years when using the pool. Last year, the pool lift broke, and management has told Miko that they don't have the money to pay for it to be repaired or replaced, and they are not a recipient of government assistance and are required to pay for reasonable modifications. Management tells Miko that they will permit her to replace the lift at her own expense as a modification for her disability. Do you think management has violated the law? Has management violated the law? The answer is yes. So even though the property doesn't get any financial assistance from the government, they're still required to pay for the repair. And this is because the lift is an accessible feature that existed when Miko rented the property, and it broke because it wasn't being maintained. And so the housing provider failed to maintain this lift into the pool, and so they are required to fix it and maintain it. Okay, so we're going to end here. I'm providing you a link with resources on our website related to the rights of people with disabilities in housing. And I also want to invite you to our live webinars. We do them twice a month now. We do Housing Discrimination 101. We do Fair Housing Rights for People with Disabilities, Employment Discrimination 101, and Legal Protections for workers with disabilities on a regular basis. And the link that I provided can bring you to the page where you can register and see a list of all our upcoming webinars. And I just want to thank you for being here and listening along. And here's contact information again for the Civil Rights Department. And I hope you found this training to be helpful and useful. And I look forward to you joining us at another webinar or training in the future. Thank you.